The following presentation will provide a brief overview of the intestate process in Arkansas. Intestate is simply a legal term for dying without a will. So, if you die without a will, you're said to die intestate. There are very specific laws in the state to cover such a scenario. Simply put, if you do not decide how your property should be distributed after your death, the state of Arkansas will decide for you. Probate is the process by which the courts distribute a decedent's property after his or her death. Probate is a court proceeding, and so is a matter of public record. It can also be time-consuming. Not all property goes through probate, however. Some types of property, such as life insurance proceeds, retirement accounts, and real estate held in joint tenancy or tenancy by the entirety, generally pass automatically without having to go through the probate process. As a side note, joint tenancy is a form of property ownership in which the joint tenants share equally in the ownership of a property and will automatically inherit upon the death of another joint tenant. Tenancy by the entirety is a special kind of joint tenancy for married couples. So, if you have purchased a home with your spouse, you likely hold your home in one of these forms of ownership. Any property that does not pass automatically, that is, any non-probate property, must go through probate. From this remaining property, homestead and statutory allowances, and dower and courtesy are removed from your estate. Any remaining property will be subject to the claims of your creditors before passing according to the inheritance priorities set by state law. Homestead and statutory allowances entitle surviving spouse and children under the age of 21 to the income and profits from the homestead. As a practical matter, this generally means the right to occupy the primary residence. Only a spouse of a marriage of at least 1 year acquires these rights, and any rights a child acquires will extinguish upon the child's 21st birthday. The value of these allowances is increased by the inability of your creditors to take your home from your spouse or children to satisfy any outstanding debts you may have had upon your death. The size of the homestead is limited based on its location. A home in a rural area can be up to 160 acres, while a home inside of an urban or city environment is not protected beyond a 1 acre size. In addition, this right also entitles your spouse and minor children to a reasonable amount of furniture necessary for the occupation of the home, in addition to a very small allowance for living expenses. As I mentioned above, this right protects your spouse and children from the claims of your creditors, but the mortgage is generally exempted from this. So while your wife and minor children generally would not have to pay your credit card bills to stay in the home, they will probably have to keep paying the mortgage. After homestead allowances have been assigned, dower or courtesy rights are distributed. Dower refers to the rights of a surviving wife, and courtesy to the rights of the surviving husband, but they are essentially the same. Arkansas is one of the few remaining states that recognizes these rights, which provide the surviving spouse with the right to a portion of your estate that your creditors cannot take. If you have children, your spouse will receive a 1/3 life estate interest in your real estate and a 1/3 ownership interest in your personal property. As a side note, a life estate is an ownership interest that is limited to the life of the owner. In this situation, the practical effect of a life estate is that upon your spouse's death, your heirs, rather than your spouse's heirs, will inherit the property. If you do not have any children, your spouse will inherit half of all your property outright, though your debts may reduce this amount to as little as 1/3. The remaining amount is called the heritable estate. Your creditors have first claimed the heritable estate to pay any debts you may have had outstanding at your death. Any property that remains after your creditors have been paid will pass according to the priorities set by the state. Any property you have remaining in your heritable estate will pass to your surviving children. If you have had children predecease you, their children, if applicable, will inherit in their place. Notice that this means if you have any surviving descendants at all, your spouse will not inherit any additional property. So without a will, your spouse could inherit as little as 1/3 of your property. If, however, you do not have any surviving descendants, your spouse will inherit the rest of your property. If you've been married less than 3 years prior to your death, however, your surviving spouse will receive only half. If you are unmarried and have no children, or if you've been married less than 3 years requiring that the other half of your estate continue to pass down the priority list, your surviving parents will inherit, then your brothers and sisters, then your grandparents, uncles, and aunts, then your great-grandparents, great-uncles, and great-aunts, then, if applicable, the other half of your heritable estate to a spouse to whom you have been married less than 3 years. Usually, where a deceased individual would have inherited had they survived you, their descendants will inherit in their place. This is particularly applicable when your grandparents or your great-grandparents stand to inherit. As they would not normally outlive you, in this situation, usually cousins will inherit in their place. Finally, if you do not have any available inheritors from this list, the county will inherit your property. I hope that this has been helpful. I have included my firm's information here, so if you have any questions, please feel free to call or email me. I'm happy to help in any way that I can.